Ever wonder what goes on behind the scenes when a defendant pleads guilty to serious felony charges? Today, we're diving deep into a fascinating courtroom exchange from Ohio that reveals the meticulous process judges undertake to ensure justice is served fairly. Get ready for an inside look at a constitutional rights, competency, and the gravity of admitting guilt.
Splendid.
Thank you, Your Honor. We're here this afternoon in case caption State of Ohio versus Mecca Habib, case number 25 CR 001591. In this matter, originally a 3-count indictment was filed on December 19th, alleging 1 count of assault, a felony of the 4th degree, 1 count of obstructing official business, a felony of the 5th degree, and 1 count of resisting arrest, a misdemeanor of the 1st degree. And then on January 16th of this year, defense counsel Mr. Matthews filed a motion for competency. The case was then referred for competency evaluation. That has actually been completed by Dr. Jessica L. Hart from the Forensic Psychiatric Center of Northeast Ohio. I know that copies have been provided to both Mr. Matthews and I, my understanding is that we will both be stipulating to the findings that the defendant is in fact competent. Following that, it is my understanding that the defendant would withdraw her former plea of not guilty and enter a plea of guilty to count 1, assault, felony of the 4th degree, and count 2, obstructing official business. We will be requesting that it be referred for a pre-sentence report and an investigation and victim impact statements.
Okay. Mr. Matthews.
That is all accurate, Your Honor.
All right, with regard to the forensic report, Mr. Matthews.
Thank you, Your Honor. I have reviewed the report. Ms. Habib has been found to be competent. I reviewed all of the findings and I'm in agreement with that finding, Your Honor.
Ms. Linden. As to the report.
Oh, yes, Your Honor. We would stipulate to the report as well. I've had an opportunity to review it.
All right, based on the stipulation and the report of Dr. Hart, I'm going to find that Ms. Habib is competent to stand trial. And Ms. Habib, how old are you?
I'm 23.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you, you have been diagnosed with what, bipolar, correct?
No.
No? Isn't that what the diagnosis was in here?
I wasn't.
This is a crucial moment in any criminal proceeding, the determination of competency. In Ohio, as in all U.S. jurisdictions, a defendant must be found competent to stand trial. What does that mean? Well, under the Fifth Amendment's Due Process Clause and Article 1, Section 10 of the Ohio Constitution, a defendant is legally competent if they possess a sufficient present ability to consult with their lawyer with a reasonable degree of rational understanding and have a rational as well as factual understanding of the proceedings against them. The court is here relying on a forensic report and the stipulation of both counsel, meaning both sides agree with the findings. This ensures that Ms. Habib can meaningfully participate in her defense. But then the judge probes deeper, directly asking about a bipolar diagnosis mentioned in the report, which the defendant initially denies. This is the judge's crucial role, to not just rubber stamp, but to personally verify and ensure the defendant truly understands and is able to proceed, even when counsel has stipulated to findings. This personally inquire adds another layer of due process protection, especially when there might be a history of mental health challenges.
The report did indicate, Your Honor, findings that did reflect a
Bipolar 1.
diagnosis of bipolar, Your Honor.
All right. Do you understand everything going on here so far today?
Yes.
Okay, did you get a copy of the indictment in this case?
Yes.
All right, and my understanding is you're going to plead guilty to count 1, assault, a felony 4, and count 2, obstructing official business, a felony 5. Is that your understanding?
Yes.
Okay, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk to Mr. Matthews some more, let me know, and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these charges?
What we're witnessing here is the judge meticulously adhering to Ohio Criminal Code Rule 11, which governs guilty pleas. This rule is paramount because a guilty plea is one of the most significant steps a defendant can take, waiving numerous constitutional rights. The judge isn't just asking, "Do you understand?" and accepting a simple yes. They are individually explaining each fundamental right, such as the right to a jury trial guaranteed by the Sixth Amendment, the right to confront witnesses, the right to call one's own witnesses, and the Fifth Amendment right against self-incrimination. Then the judge explicitly asks if the defendant is waiving that specific right. This colloquy, as it's known, is designed to create a clear record that the plea is knowing, intelligent, and voluntary. The judge even goes through the right to appeal, which is also waived by a guilty plea. It might seem repetitive, but this exhaustive process is crucial to prevent future claims that the defendant didn't understand what they were giving up, protecting the integrity of the conviction and the defendant's due process rights.
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
In count one, assault is a felony of the fourth degree, carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
Count two, obstructing official business is a felony of the fifth degree with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison sentence of 30 months and a maximum fine of $7,500. Do you understand that?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, a parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If the violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to happen, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 30 months. You understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Matthews before pleading guilty today?
Yes, I've had enough time.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, I'm
Do
free.
you have any questions at this point?
No.
All right, Ms. Linden, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had the case gone to trial, the state would have submitted evidence to show beyond a reasonable doubt each of those elements that are set forth in count 1 and count 2 in the indictment. This was the result of the Mobile Police Department doing a check at Gully Brook Park and finding the defendant there. She ended up having a warrant for her arrest, and placing her under arrest ended up resulting in counts 1 and count 2.
Okay, Mr. Matthews, anything to add to those facts?
No, Your Honor.
All right, Ms. Bahabi, did you hear what Ms. Linden said that the facts would show if the case went to trial?
Yes.
And are those facts true?
Yes.
All right, what is your plea to count 1, assault, a felony of the 4th degree?
Guilty.
What is your plea to count 2, obstructing official business, a felony of the 5th degree?
Guilty.
Here, the prosecutor lays out the factual basis for the charges, outlining what the state would have been proven had the case gone to trial. This step is crucial for the court to ensure there's a sufficient foundation for the guilty plea. Assault as a felony of the 4th degree under Ohio Revised Code Section 2903.13 typically involves a specific circumstance, such as the victim being a peace officer or serious physical harm occurring. Obstructing official business, a felony of the 5th degree under Ohio Revised Code Section 2921.31 means the defendant purposely hampered or impeded a public officer in their duties. And importantly, the violation created a risk of physical harm. By having Ms. Habib affirm that these facts are true, the judge further solidifies the knowing and voluntary nature of her plea. She's not just admitting guilt, she's confirming the underlying actions that constitute these crimes. This direct confirmation from the defendant is a final safeguard before the court formally accepts the plea and moves forward towards sentencing.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the written plea of guilty with Ms. Habib. She indicated that she understood it and that she intended to sign it. Okay, put the date on this line, 2/10/26. Sign on this one.
Your Honor, please recommend handing the written plea of guilty and judgment entry. It has been signed here today in open court by the defendant. Mr. Matthews and I have also signed that document.
All right, Ms. Habib, is this your signature on this written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept the written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present with Mr. Matthews. Advised of all of her rights, made a knowing, intelligent, and voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Finally, to be knowing, intelligent, and voluntary, I will accept her plea of guilty. find her guilty of count 1, assault, a felony 4, and count 2, obstructing official business, a felony 5. I'm going to refer this for a pre-sentence report. Victim impact statement. Sentencing will be March 13 at 1:30. Bond is revoked. Anything else, Ms. Linden?
No, Your Honor, thank you.
Matthew?
No, Your Honor, thank you.
All right, we're adjourned.
Following her plea of guilty to assault, a felony of the 4th degree, and obstruction of official business, a felony of the 5th degree, Mecca Habib's sentencing was scheduled for March 13th at 1:30 p.m. The judge referred the case for a pre-sentence report and victim impact statements to aid in determining the appropriate sentence. While Ms. Habib was found eligible for judicial release, a mechanism for early release from the prison, the specific details of her final sentence, including any prison time, community control, or fines for this particular case, are not readily available in public court records at this time of research. However, the legal process highlights the meticulous steps taken by courts to ensure constitutional rights are protected, even when a defendant chooses to plead guilty.